In the matter of JOMON KK versus SHAJIMON P, Supreme Court dismissed the appeals and said that appellant having gained entry through the process which was not legal and valid, this is not a fit and proper case where the court could exercise power under Article 142 of the Constitution. The central question of law arising for decision on the appeal was whether the appellant, who did not hold a current Laskar's license but was the holder of a Sirang's license, could have been considered qualified to participate in the recruitment process as well as appointed. Court said we shall assume for a moment that though the process was commenced for appointment on vacant posts of Laskar, there was no illegality in persons having Sirang's license being permitted to participate. There could be aspirants holding Laskar's license in sufficient numbers who might not have the higher qualifications necessary for even appearing for a viva voce to aim at possessing a certificate of competency as Sirang. Those aspirants holding a Laskar's license might not also be capable or competent for obtaining a Sirang license. After all individuals are not blessed with the same level of intelligence, human abilities, and intellect. The distribution of innate abilities and intellectual prowess being far off from uniform, resulting in a diverse spectrum of human potential, it is axiomatic that aspirants having only a Laskar's license can never be considered for direct recruitment on any post in Class 3 of subordinate service other than a Laskar. It is quite but natural that in the matter of observation, perception, and memorization of details of principles of navigation and skill in respect of seamanship, there would be significant differences in faculties of different individuals. Court said that we are ad idem with the division bench of the High Court that KPSC could not have included candidates with licenses other than a Laskar's license in the ranked list and proceed to recommend those candidates for appointment. On merits, therefore, no legally protected right of appellant having been affected by impugned action, he has no valid claim. Supreme Court added that whether or not the action of the employer to exclude an aspirant from process of selection on ground that either he is overqualified for a post or has qualifications which being over and above what is ordained by statutory rules or rules framed under proviso to rule 309 of constitution does not match the qualifications specifically required is justified has to be decided considering rules governing the selection, the qualifications prescribed, the nature of the duty to be performed, the nature of services to be rendered, and a host of other factors. It has to be remembered that at times employers need have the right people at the right place and not always the higher qualified has to be considered. We know of decisions, Supreme Court said, holding that overqualification cannot be a disqualification since such an approach amounts to discouraging the acquisition of qualifications on one hand, and on the other, such an approach could be seen as arbitrary, discriminatory, and not in national interest. However, this principle cannot be put in a straitjacket imposing rigid or inflexible rules or norms. Lack of public employment opportunities in sufficient numbers may force even master degree holder to apply for job of peon, but if he is appointed upon his application being favorably considered, what happens to the aspirants who have not had the means of pursuing study beyond the 12th standard? Do they remain unemployed forever if all or majority of the posts of peon are filled up by such degree holders? What happens if the master degree holder, in pursuit of greener pastures, leave the post of peon for a better and secured higher job commensurate with his qualifications after a couple of years? Does it not, in such a case, burden the public exchequer by requiring employer to initiate a fresh selection process? Is not the state, as a model employer, obliged to ensure that posts of peon are filled up only by those having basic qualification and not by overqualified candidates for subserving the common good? Does not the state have the obligation to strive to ensure that all citizens have adequate means of livelihood? These are questions which no court can afford to ignore. Court said we end by saying that each case that comes before the court has to be decided on its own peculiar facts and problems that it presents for resolution, and there can be no universally accepted rule that every time a higher qualified candidate is to be preferred to a candidate who matches the essential qualification required for the post. Exercise of power under Article 142 of the Constitution would have been warranted in the present case if palpable injustice were demonstrated. Court in Ashok Kumar Sonkar versus Union of India held that if an appointment is illegal, it is non-est in the eyes of law, and rendering appointment a nullity and principles of equity in case of such nature would have no role to play. Also, that sympathy should not be misplaced.